Jordan's 2311 Racing has just made a fantastic move that might change everything after NASCAR fired back at them once more. The racing governing body has submitted a motion to amend its counterclaim, dismissing what it claims strong evidence against the team co-owned by NBA icon Michael Jordan and current driver Denny Hamlin. This surprising new discovery hinges around NASCAR's claims that they discovered catastrophic proof within more than 200,000 pages of emails. According to these records, 2311 Racing and Front Row Motorsports engaged in lawful coordination with competing teams. The timing could hardly be more important, as both parties prepare for a December trial. What did NASCAR find? According to their case in the United States District Court for the Western District of North Carolina, Charlotte Division, the evidence includes emails, texts, and memoranda that NASCAR believes are indisputable proof of its charges against the teams and Jordan's business partner Curtis Polk. To grasp the relevance of these new claims, we must first consider how this contentious judicial dispute began. The controversy began in October 2024, when 2311 Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR. The teams argued that NASCAR's charter structure enabled anti-competitive and monopolistic behavior. This arrangement, which guaranteed team slots in races and some financial considerations, sparked a violent feud when both 2311 and FRM refused to sign NASCAR's take-it-or-leave-it charter deal for the 2025 season. Jordan's 2311 and Bob Jenkins' Front Row Motorsports did not complete the agreement by the deadline of September 20, 2024. Their denial sparked a flurry of legal action, which has now increased dramatically with NASCAR's current lawsuit. NASCAR's charter structure is designed to offer teams with financial stability and guaranteed race spots. Essentially, charter teams are guaranteed participation in every race as well as a certain money split. Both 2311 and FRM contend that the current setup restricts fair competition and allows NASCAR to dominate the sport. The teams argue that the funding arrangement is unfair and does not provide them with a viable business framework. For comparison, according to the most recent charter agreement signed by other teams, NASCAR claims teams will receive around 49% of the proceeds from the new 7-year, $1.1 billion average per year TV rights deal. According to NASCAR's attorney Chris Yates, this is an increase from 38 to 40% in the last agreement in March 2025. NASCAR replied by filing a countersuit against the teams. They described 2311 and FRM as an illegal cartel, accusing them of deliberately breaking antitrust laws by coordinating anti-competitive collective action. NASCAR identified Curtis Polk, Michael Jordan's longtime business associate and 2311 co-owner, as the mastermind behind these initiatives. This accusation prompted Jordan to claim that the lawsuit had become personal. Now, with this recent filing on April 18, 2025, NASCAR claims to have actual evidence to back up these serious allegations. They are demanding permission from the court to amend their counterclaim to include passages from previously discovered documents. What exactly does NASCAR claim to have found? According to their filing, the papers show that 2311, Front Row, and Curtis Polk purposefully entered into illegal agreements with other teams over a number of critical issues. These alleged agreements included determining how much money they would receive from NASCAR and distributing that money among the co-conspirator teams, with Jonathan Marshall of the Race Team Alliance acting as a conduit for these transactions. The complaint goes further, noting, although its existing counterclaim more than adequately states a claim for relief, NASCAR seeks leave to file an amended counterclaim that includes excerpts of these recently produced documents because they confirm beyond any doubt that 2311 and Front Row reached unlawful agreements with each other and other teams, and that Curtis Polk was the ringleader. The sanctioning organization claims Polk led efforts to set team salaries, boycott NASCAR races, interfere with NASCAR's dealings with media partners, and negotiate illegal agreements. The teams answered swiftly and strongly. Attorney Jeffrey Kessler, who represents both 2311 and Front Row Motorsports, blasted NASCAR's latest claims as a needless distraction and a desperate attempt to shift attention away from the company's own illegal monopolistic tactics. NASCAR's answer to our motion to dismiss, as well as their need to alter their counterclaim, demonstrate the flaws in their reasoning. Kessler stated that their first lawsuit sought to make NASCAR more competitive and fair to drivers, fans, sponsors, and teams. These filings make no difference, and we are looking forward to presenting our case at trial. This letter reveals how the teams viewed NASCAR's counterclaims as a strategic legal maneuver rather than a substantive complaint with merit. An fascinating aspect of this legal drama is the club's attempts to obtain financial information from other large sports companies. In early April, 23XI and FRM went to court to enforce subpoenas issued to the NFL, NBA, NHL, and Formula One. The teams want to match their sports financials to NASCAR's approach. According to their complaint, this information would enable plaintiffs to draw a yardstick comparison between the other major professional sports leagues, where competition is permitted, and NASCAR, where exclusionary behavior has been used to unjustly maintain a monopoly. The NFL strongly opposed this request, arguing the following. The subpoena is based on the flimsiest of premises, that because plaintiffs are suing NASCAR, they can obtain by way of federal process financials, financial projections, research studies, analyses, and other highly confidential, proprietary, and commercially sensitive information belonging to almost every other major sports league in the United States. This debate over comparative financial data illustrates the case's central question. Is NASCAR's revenue-sharing arrangement equitable in comparison to other big sports? The teams had a significant victory in December 2024 when U.S. District Court Judge Kenneth Bell granted their application for a preliminary injunction. This decision enabled NASCAR to allow 23XI and FRM to sign charter agreements supplied in early September, as well as to approve the transfer of charters each team intended to purchase from Stewart-Haas Racing. To obtain this injunction, the teams needed to succeed in 4 areas. Likelihood of success. The judge found that the provision of the charter agreement that releases NASCAR from legal claims would most likely be declared unconstitutional. Irreparable injury. The judge accepted that drivers and sponsors might leave the teams if they were unable to compete as chartered teams. Equities balancing. The judge determined that while the injunction would not influence NASCAR, it would cause significant harm to the teams if it did not exist. Public interest. According to the judge, NASCAR fans want to see all teams compete with their best drivers and teams. Furthermore, the public is concerned with protecting plaintiffs' rights to pursue legal claims in good faith, particularly antitrust lawsuits aimed at preserving the process of economic competition. NASCAR contested the verdict, and a hearing has been scheduled for May 9, 2025, in the United States Court of Appeals in Richmond. Jimmy Johnson, a NASCAR great, has spoken out about what he thinks the sport will look like once the legal battle is resolved. During an appearance on the Business of Sport podcast, Johnson remarked that he believes NASCAR will evolve into a structure more like to other sports leagues. So, this year, we're heading to Mexico City for the first championship points-paying event in the Top Series history. One of the races was held in Chicago, where a street circuit exists. So, as we go ahead, and there are some whispers about NASCAR eventually selling a chunk of itself and becoming more of a league, we're all waiting and believe there's tremendous promise there. And when we form a league, I believe all ships in the port will rise even more. Johnson believes NASCAR has a long way to go before reaching the same heights as other American sports leagues due to the sport's steady evolution. Johnson compared the situation to recent changes in other sports, saying, "And the more I dig in, the more I understand. This just happened in Formula One. This occurred not long ago in the NBA, and I believe we're on the same path toward becoming a proper league, which must evolve." NASCAR's principal defense against antitrust claims is to question the definition of the market. They argue that confining the market to just cup racing is overly restrictive for antitrust purposes. Instead, NASCAR believes that the relevant market should include all motorsports, or even the entire sports landscape. This distinction is important because antitrust law focuses on whether an entity has monopoly power in a given market. In contrast, the teams argue that NASCAR Cup Series racing has its own separate market. In his injunction decision, Judge Kenneth Bell recognized that the availability of several sports in the United States does not imply NASCAR's domination over a major one, just as the presence of professional basketball and football does not imply the NCAA's monopoly over collegiate basketball and football. So what do you think? Does NASCAR have a shot in this case? Will they beat 23XI to the choice when the time comes? Let me know your opinions in the comments section below,